All rise. Veuillez vous lever. The International Criminal Tribunal for the former Yugoslavia is now in session. L'audience tribunaal pénal internationaal pour l'ex-Yougoslavie est ouverte.
Please be seated. Good afternoon, Registrar. Could you please call the case?
This is case number ITO 481A, the prosecutor versus Momcilo Perisic. Thank you, Your Honor.
Thank you. Mr. Perisic, can you follow the proceedings in a language you understand?
Da, mogu da pratim.
Thank you. Let me now ask for appearances by the parties. First, counsel for Mr. Perisic, please.
Dobar dan, poštovani sude I dobar dan
Good
svim
morning, Your Honors.
učesnicima u
Good
postupku.
morning to all the
Gospodina
participants in the
Perišića danas
proceedings.
u sudnici
Today,
zastupam ja kao
Mr.
glavni
Perisic will
advokat.
be
Moje ime je
represented by
Novak
myself
Lukić, sa mnom
as
je
the chief
gospodin
counsel.
Gregor
I
Gaj
am Novak
Smith kao
Lukić
pomoćni
and I'm
advokat.
accompanied by
Sa
Mr.
nama su
Gregor Gaj
sudnici
Smith
naši
as
pravni
the
asistenti
assistant
Tina Doralec,
defense counsel,
Boris
and we have
Zorko
our
I
assistants
Čedmer,
Tina
kao I
Doralec,
naš inter
Boris
Marijan
Zalko, Čedmer,
Jakthag.
as well
Thank
as
you,
our
counsel.
inter Marian Jachtheld.
For the prosecutor, please.
Good afternoon, Your Honours. Helen Brady appearing on behalf of the prosecution. With me today, Ms. Eleanor Martin Salgado, Ms. Bronna McKenna, Ms. Virginie Monchi, and our case manager, Mr. Colin Nayrod.
Thank you, Ms. Brady. As the registrar announced, the case on our agenda today is prosecutor against Momcilo Perisic. In accordance with the scheduling order issued on 15 February 2013, today the appeals chamber will deliver its judgment. Following the practice of the tribunal, I will not read out the text of the appeal judgment except for the disposition, but instead will summarize the essential issues on appeal and the central findings of the appeals chamber. This oral summary does not constitute any part of the official and authoritative judgment of the appeals chamber, which is rendered in writing and will be distributed to the parties at the close of the hearing. This case concerns events that occurred between at least August 1993 and November 1995 in the territory of Bosnia-Herzegovina, or Bosnia, and the Republic of Croatia, or Croatia, starting on 26 August 1993, and through the rest of this period, Mr. Perisic was the chief of the General Staff of the Yugoslav Army, or VJ, a position that made him the VJ's most senior officer. During this period, the VJ facilitated the provision of military and logistical aid to the Army of Republika Srpska, or VRS, in Bosnia and Herzegovina, and to the Army of the Serbian Krajina, or SVK, in Croatia. The trial chamber, Judge Moloto dissenting, found Mr. Perisic guilty as an aider and abettor of the following crimes committed by the VRS in the Bosnian towns of Sarajevo and Srebrenica. murder, inhumane acts and persecutions as crimes against humanity, and murder and attacks on civilians as violations of the laws or customs of war. The trial chamber, Judge Moloto dissenting, also found Mr. Perisic guilty as a superior for failing to punish the following crimes related to SVK shelling of Zagreb on 2 and 3 May 1995. Murder and inhuman acts as crimes against humanity, and murder and attacks on civilians as violations of the laws or customs of war. Mr. Perisic was sentenced to 27 years of imprisonment. Mr. Perisic submitted 17 grounds of appeal challenging his convictions and his sentence. He requested the appeals chamber reverse all of his convictions, or, in the alternative, that his sentence be reduced. The appeals chamber now turns to Mr. Perisic's contentions, addressing first his grounds of appeal regarding his convictions for aiding and abetting crimes in Sarajevo and Srebrenica. Mr. Perisic, in his first through 12th ground of appeal, submits that the trial chamber erred in convicting him of aiding and abetting crimes committed by the VRS in Sarajevo and Srebrenica. In particular, Mr. Perisic asserts that the trial chamber erred in holding that acts of an aider and abettor need not be specifically directed towards assisting the commission of charged crimes. He further contends that the trial chamber committed a number of additional errors with respect to his conviction for aiding and abetting. The prosecution responds that the trial chamber did not err in convicting Mr. Perisic of aiding and abetting the VRS crimes in Sarajevo and Srebrenica. The appeals chamber recalls that the trial chamber concluded that specific direction is not an element of the actus reus of aiding and abetting. The trial chamber accordingly declined to consider whether Mr. Perisic specifically directed aid towards charged VRS crimes. The trial chamber found that Mr. Perisic made a substantial contribution to these crimes, knew that his aid assisted the crimes in Sarajevo and Srebrenica, and was aware of the general nature of the crimes. Based on these findings, the trial chamber found Mr. Perisic guilty of aiding and abetting VRS crimes in Sarajevo and Srebrenica. The appeals chamber recalls that specific direction was first described as a requisite element of the actus reus of aiding and abetting liability in the 1999 Tajik appeal judgment. To date, no judgment of the appeals chamber has found cogent reasons to depart from the definition of aiding and abetting liability adopted in the Tajik appeal judgment. Moreover, many subsequent appeal judgments have explicitly referred to specific direction in enumerating the elements of aiding and abetting, often repeating verbatim the Tajik appeal judgment's relevant holding. The trial chamber relied upon the 2009 Merksic and Slivančanin appeal judgment in holding that specific direction was not a required element of the actus reus of aiding and abetting. The appeals chamber notes that the Merksic and Slivančanin appeal judgment stated, in passing that specific direction is not an essential ingredient of the actus reus of aiding and abetting. The Appeals Chamber recalls its settled practice to only depart from a previous decision after the most careful consideration has been given to it, both as to the law, including the authorities cited, and the facts. The Merksic and Slivanchening appeal judgments passing reference to specific direction does not amount to such careful consideration. Had the Appeals Chamber found cogent reasons to depart from its relevant precedent and intended to do so, it would have performed a clear, detailed analysis of this issue, discussing both past jurisprudence and the authorities supporting an alternative approach. Instead, the relevant reference to specific direction was made in a section and paragraph dealing with mens rea, rather than actus reus, was limited to a single sentence, not relevant to the Appeals Chamber's holding, did not explicitly acknowledge a departure from prior precedent, and, most tellingly, cited only one previous appeal judgment, which in effect confirmed that specific direction does constitute an element of aiding and abetting liability. This indicia suggests that the formula, not an essential ingredient, was not meant to depart from previous jurisprudence establishing that specific direction is an element of aiding and abetting liability. Accordingly, the Appeals Chamber, Judge Liu dissenting, considered that specific direction remains an element of aiding and abetting liability and reaffirms that no conviction for aiding and abetting a crime may be entered if specific direction has not been proved beyond reasonable doubt. The Appeals Chamber, Judge Liu dissenting, records that the element of specific direction establishes a culpable link between assistance provided by an accused individual and the crimes of principal perpetrators. In many cases, evidence relating to other elements of aiding and abetting liability may be sufficient to demonstrate specific direction and thus the requisite culpable link. In this respect, the Appeals Chamber notes that previous appeals judgments of the tribunal have not conducted extensive analysis of specific direction. The lack of such discussion may be explained by the fact that prior convictions for aiding and abetting entered or affirmed by the Appeals Chamber involved relevant acts geographically or otherwise proximate to, and thus not remote from, the crimes of principal perpetrators. Where such proximity is present, specific direction may be demonstrated implicitly through discussion of other elements of aiding and abetting liability, such as substantial contribution. However, not all cases of aiding and abetting will involve proximity of an accused individual's relevant acts to crimes committed by principal perpetrators. Where an accused aider and abettor is remote from relevant crimes, evidence proving other elements of aiding and abetting may not be sufficient to prove specific direction. In such circumstances, the Appeals Chamber, Judge Liu dissenting, holds that explicit consideration of specific direction is required. The Appeals Chamber observes that Mr. Perisic's assistance to the VRS was remote from the relevant crimes of principal perpetrators. In particular, the trial chamber found that the VRS was independent from the VJ and that the two armies were based in separate geographical regions. In addition, the trial chamber did not refer to any evidence that Mr. Perisic was physically present when relevant criminal acts were planned or committed. In these circumstances, the Appeals Chamber, Judge Liu dissenting, considers that an explicit analysis of specific direction would have been required in order to establish the necessary link between the aid Mr. Perisic provided and the crimes committed by principal perpetrators. Accordingly, the Appeals Chamber, Judge Liu dissenting, considers that the trial chamber committed an error of law by not considering whether specific direction was proved in this case. The Appeals Chamber will thus proceed to assess the evidence relating to Mr. Perisic's convictions for aiding and abetting de novo under the correct legal standard, considering whether Mr. Perisic's actions were specifically directed to aid and abet the VRS crimes in Sarajevo and Srebrenica. The Appeals Chamber notes that previous judgments have not provided extensive analysis of what evidence may prove specific direction. However, the Appeals Chamber recalls that specific direction involves finding a link between an accused aider and abettor and the crimes committed by principal perpetrators. The Appeals Chamber considers that the types of evidence required to establish such a link will depend on the facts of a case. However, in most situations, the provision of general assistance, which could be used for both lawful and unlawful activities, will not be sufficient alone to prove that this aid was specifically directed to crimes of principal perpetrators. In order to determine whether the VJ assistance facilitated by Mr. Perisic was specifically directed to the commission of the VRS crimes in Sarajevo and Srebrenica, the Appeals Chamber considers relevant evidence on the record de novo, taking into account, where appropriate, the trial chamber's findings. As a preliminary matter, the Appeals Chamber recalls that the VRS was neither de jure nor de facto subordinated to the VJ. The Appeals Chamber will now consider whether VJ assistance to the VRS that Mr. Perisic acknowledges having facilitated was specifically directed towards VRS crimes. In this regard, the Appeals Chamber will assess Mr. Perisic's role in shaping and implementing the Federal Republic of Yugoslavia's policy of supporting the VRS, whether this policy of supporting the VRS was specifically directed towards the commission of certain crimes by the VRS, and whether Mr. Perisic either implemented the Federal Republic of Yugoslavia Supreme Defense Council or SDC policy of assisting the VRS in a way that specifically directed aid to the VRS crimes in Sarajevo and Srebrenica, or took action to provide such aid outside the context of SDC-approved assistance. The Appeals Chamber underscores that the parameters of its inquiry are limited and focus solely on factors related to Mr. Perisic's individual criminal liability for the VRS crimes in Sarajevo and Srebrenica, not the potential liability of states or other entities over which the tribunal has no pertinent jurisdiction. The Appeals Chamber also underscores that its analysis of specific direction will exclusively address actus reus. In this regard, the Appeals Chamber acknowledges that specific direction may involve considerations that are closely related to questions of mens rea. Indeed, as discussed below, evidence regarding an individual's state of mind may serve as circumstantial evidence that assistance he or she facilitated was specifically directed towards charged crimes. However, the Appeals Chamber recalls again that the mens rea required to support a conviction for aiding and abetting is knowledge that assistance aids the commission of criminal acts, along with awareness of the essential elements of these crimes. By contrast, as set out above, the long-standing jurisprudence of the tribunal affirms that specific direction is an analytically distinct element of actus reus. The Appeals Chamber recalls that Mr. Perisic served as the most senior officer of the VJ during the relevant period and was responsible for ensuring combat readiness and organizing VJ operations. Mr. Perisic was subordinated to the President of the Federal Republic of Yugoslavia and ultimate authority on defense policy and operational priorities for the VJ rested with the SDC. While SDC meetings were attended by many individuals, including Mr. Perisic, final SDC decisions were taken by political leaders, the President of the Federal Republic of Yugoslavia, and the Presidents of the Republics of Serbia and Montenegro. The decision to provide VJ assistance to the VRS was adopted by the SDC before Mr. Perisic was appointed Chief of the VJ General Staff, and the SDC continued to support this policy during Mr. Perisic's tenure in this position. Mr. Perisic regularly attended and actively participated in meetings of the SDC, and he was delegated the legal authority by the SDC to administer assistance to the VRS. However, the SDC retains the power to review both particular requests for assistance and the general policy of providing aid to the VRS. The Appeals Chamber recalls that the SDC's ultimate authority over the policy of aiding the VRS does not, in and of itself, exempt Mr. Perisic from criminal liability. In assessing whether Mr. Perisic is liable for aiding and abetting the VRS crimes in Sarajevo and Srebrenica, the Appeals Chamber will first consider whether the SDC policy of aiding the VRS was itself directed to facilitate criminal activities. This could be shown either by a finding that the VRS was an entirely criminal organization, or by a finding that the SDC targeted its aid towards the VRS crimes. The appeals chamber recalls that the trial chamber did not characterize the VRS as a criminal organization. Having reviewed the evidence on the record, the appeals chamber agrees with the trial chamber that the VRS was not an organization whose actions were criminal per se. Instead, it was an army fighting a war. The appeals chamber notes the trial chamber's finding that the VRS strategy was inextricably linked to crimes against civilians. However, the trial chamber did not find that all VRS activities in Sarajevo or Srebrenica were criminal in nature. The trial chamber limited its findings to characterizing as criminal certain actions of the VRS in the context of the operations in Sarajevo and Srebrenica. In these circumstances, the appeals chamber considers that the policy of providing assistance to the VRS general war effort does not, in itself, demonstrate that aid facilitated by Mr. Perisic was specifically directed aid to the VRS crimes in Sarajevo and Srebrenica. Further, neither the trial chamber's conclusions nor the appeals chamber's de novo review of the evidentiary record reveals any basis for concluding that SDC policy specifically directed aid towards VRS crimes. Instead, the SDC focused on monitoring and modulating aid to the general VRS war effort. For example, SDC discussions address difficulties in providing particular levels of assistance requested by the VRS, salaries of VJ personnel seconded to the VRS, and how to react when members of the VJA provided supplies to the VRS without official approval. The appeals chamber observes that, although the trial chamber considered the magnitude of aid provided to VRS in concluding that VJ assistance substantially contributed to VRS crimes in Sarajevo and Srebrenica, evidence regarding volume of assistance does not necessarily establish specific direction. In the circumstances of this case, indicia demonstrating the magnitude of VJ aid to the VRS serve as circumstantial evidence of specific direction. However, a finding of specific direction must be the sole reasonable inference after a review of the evidentiary record as a whole. In this context, the appeals chamber Judge Liu dissenting considers that a reasonable interpretation of the evidence on the record is that CDS directed large-scale military assistance to the general VRS war effort, not to the commission of VRS crimes. Accordingly, specific direction of VJ aid towards VRS crimes is not the sole reasonable inference that can be drawn from the totality of the evidence on the record, even considering the magnitude of VJ's assistance. In view of the foregoing, the appeals chamber, Judge Liu dissenting, concludes that the SDC policy of assisting the VRS was not proved to be specifically directed towards VRS crimes as opposed to the general VRS war effort. Because the assistance provided to the VRS was not in furtherance of specific crimes, the appeals chamber considers that, insofar as Mr. Perisic faithfully executed the SDC policy of supporting the VRS, the aid Mr. Perisic facilitated was not specifically directed towards the latter's criminal activities, inclusive of the VRS crimes in Sarajevo and Srebrenica. And the appeals chamber now considers whether Mr. Perisic implemented the CDC policy of assisting the VRS war effort in a manner that redirected aid towards VRS crimes, or whether Mr. Perisic took separate actions to the same effect. In this regard, the appeals chamber will consider Mr. Perisic's role in SDC deliberations, as well as the nature of the assistance he provided to the VRS and the manner in which this aid was distributed. Finally, the appeals chamber will consider whether Mr. Perisic took actions independent of his efforts to implement the CDC policy, indicating that aid he facilitated was specifically directed towards the VRS crimes in Sarajevo and Srebrenica. The appeals chamber first notes that evidence relating to Mr. Perisic's discussions at meetings of the SDC does not suggest that he advocated specifically directing aid to support VRS crimes. The trial chamber found that Mr. Perisic supported continuation of the CDC policy of assisting the VRS. During meetings of the SDC, he argued both for sustaining aid to the VRS and for adopting related legal and financial measures that facilitated such aid. However, based on the trial chamber's analysis and a de novo review of the evidence, the appeals chamber, Judge Liu dissenting, finds that there is no proof that Mr. Perisic supported the provision of assistance specifically directed towards the VRS criminal activities. Instead, evidence on the record suggests that Mr. Perisic's relevant actions were intended to aid the VRS overall war record. The appeals chamber observes that Mr. Perisic had considerable discretion in providing assistance to the VRS, including the power to deny requests for aid not submitted through official channels. While it is possible that Mr. Perisic could have used this power to divert SDC-approved aid specifically towards VRS criminal activities, the trial chamber did not make any findings to that effect. And the appeals chamber's review of relevant evidence also suggests that Mr. Perisic simply directed assistance towards the general VRS war effort within the parameters set by the SDC. The appeals chamber recalls that indicia demonstrating the nature and distribution of VJ aid could also serve as circumstantial evidence of specific direction. With respect to the specific types of assistance facilitated by the VJ through Mr. Perisic, the appeals chamber, Judge Liu dissenting, finds that neither the secondment of VJ soldiers to the VRS nor the provision of logistical aid appear incompatible with lawful military operations. The appeals chamber also finds that evidence on the record does not prove that Mr. Perisic took steps in contexts outside the scope of SDC policy to assist VRS crimes. The Appeals Chamber recalls again that the VRS undertook inter alia lawful combat activities and was not a purely criminal organization. In this context, the Appeals Chamber, Judge Liu dissenting, considered that a reasonable interpretation of relevant circumstantial evidence is that while Mr. Perisic may have known of VRS crimes, the VJ aid he facilitated was directed towards the VRS general war effort rather than VRS crimes. Accordingly, the Appeals Chamber, Judge Liu dissenting, holds that Mr. Perisic was not proved beyond reasonable doubt to have facilitated assistance specifically directed towards the VRS crimes in Sarajevo and Srebrenica. The Appeals Chamber, Judge Liu dissenting, has clarified that in view of the remoteness of Mr. Perisic's actions and the crimes of the VRS, an explicit analysis of specific direction was required. As detailed above, the Appeals Chamber has reviewed the Trial Chamber's general evidentiary findings and conducted a de novo assessment of evidence on the record. In sum, the Appeals Chamber, Judge Liu dissenting, is not convinced that the only reasonable interpretation of the totality of this circumstantial evidence is that Mr. Perisic specifically directed aid towards VRS crimes. Instead, a reasonable interpretation of the record is that VJ aid facilitated by Mr. Perisic was directed towards the VRS general war effort rather than VRS crimes. Accordingly, the Appeals Chamber, Judge Liu dissenting, is not convinced that the VJ aid which Mr. Perisic facilitated was proved to be specifically directed towards the VRS crimes in Sarajevo and Srebrenica. As demonstrated above, the Appeals Chamber considers that assistance from one army to another army's war efforts is insufficient in itself to trigger individual criminal liability for individual aid providers, absent proof that the relevant assistance was specifically directed towards criminal activities. The Appeals Chamber underscores, however, that this conclusion should in no way be interpreted as enabling military leaders to deflect criminal liability by subcontracting the commission of criminal acts. If an ostensibly independent military group is proved to be under the control of officers in another military group, the latter can still be held responsible for crimes committed by their puppet forces. Similarly, aid from one military force specifically directed towards crimes committed by another force can also trigger aiding and abetting liability. However, as explained above, a sufficient link between the acts of an individual accused of aiding and abetting a crime and the crime he or she is charged with assisting must be established for the accused individual to incur criminal liability. Neither the findings of the trial chamber nor the evidence on the record in this case prove such a link with respect to Mr. Perisic's actions. After carefully reviewing the evidence on the record, the Appeals Chamber, Judge Liu dissenting, concludes that it has not been established beyond reasonable doubt that Mr. Perisic carried out acts specifically directed to assist, encourage, or lend moral support to the perpetration of the specific crimes committed by the VRS. Accordingly, Mr. Perisic's convictions for aiding and abetting must be reversed on the ground that not all the elements of aiding and abetting liability have been proved beyond reasonable doubt. For the foregoing reasons, the Appeals Chamber, Judge Liu dissenting, grants Mr. Perisic's second and third grounds of appeal in part, insofar as they relate to his convictions for aiding and abetting, and reverses his convictions under counts 1, 2, 3, 4, 9, 10, 11, and 12 of the indictment. In view of this finding, Mr. Perisic's remaining arguments in his first through 12th grounds of appeal are dismissed as moot. Mr. Perisic, in his 13th ground of appeal, submits that the trial chamber erred in law and in fact in determining that he was in a superior subordinate relationship with the members of the VJ seconded to the SVK at the time of the shelling of Zagreb on 2nd and 3rd of May 1995. The prosecution responds that the trial chamber did not err in its conviction of Mr. Perisic for failing to punish the crimes of the VJ soldiers serving in the SVK who committed crimes in Zagreb. The trial chamber's finding of superior responsibility was based in part on Mr. Perisic's position as a senior officer of the VJ. More specifically, the trial chamber found that some members of the VJ, including the perpetrators of charged crimes in Zagreb, were seconded from the VJ to assist war efforts of the Republic of Serbian Krajina. These VJ soldiers, seconded to the SVK, were administratively assigned to a unit of the VJ named the 40th PC, which provided inter alia their salaries, housing, and educational and medical benefits during secondment. The Appeals Chamber recalls that a superior cannot be held criminally liable for the acts of his subordinates unless, among other factors, he exercised effective control over those subordinates. The Appeals Chamber further recalls that an accused may not be held liable under Article 7(3) of the statute for failure to punish crimes that were committed by a subordinate before the accused assumed command over the subordinate. As an initial matter, the Appeals Chamber notes that the trial chamber did not sufficiently discuss and analyze the evidence of relevant witnesses. In context, this constituted a failure to provide a reasoned opinion and thus an error of law. In view of the trial chamber's legal error, the Appeals Chamber will proceed to assess the evidence relevant to Mr. Perisic's exercise of effective control de novo. The evidence relating to Mr. Perisic's effective control is circumstantial and can support a finding of effective control only if this is the only reasonable interpretation of the record. In order to determine whether Mr. Perisic exercised effective control over the perpetrators of crimes in Zagreb, the Appeals Chamber will consider relevant evidence, taking into account, as appropriate, the trial chamber's relevant findings. The Appeals Chamber first recalls that SVK forces shelled Zagreb on 2 and 3 May 1995, resulting in the death and injuries of civilians. The trial chamber found that this shelling was ordered by Milan Seleketic, a VJ soldier seconded to the SVK through the 40th PC on the basis of instructions from Republic of Serbian Krajina President Milan Martic. The trial chamber also found that during the SVK attacks in Croatia, Mr. Perisic instructed Seleketic not to shell Zagreb. However, these instructions were not obeyed. The Appeals Chamber considers evidence regarding Mr. Perisic's ability to issue binding command orders to VJ personnel seconded through the 40th PC. However, having carefully considered relevant circumstantial evidence, the Appeals Chamber is not convinced that the only reasonable conclusion is that Mr. Perisic could issue command orders to seconded VJ soldiers at the time of the shelling of Zagreb. The Appeals Chamber also considers evidence concerning Mr. Perisic's ability to discipline VJ soldiers seconded through the 40th PC. The trial chamber noted that Mr. Perisic was involved in disciplinary proceedings against VJ soldiers seconded through the 40th PC following the fall of the Republic of Serbian Krajina several months after the crimes in Zagreb took place. However, the Appeals Chamber notes evidence that SVK forces came under direct VJ control after the fall of the Republic of Serbian Krajina. In these circumstances, a reasonable interpretation of this evidence is that Mr. Perisic only acquired disciplinary powers over VJ members seconded to the SVK after the shelling of Zagreb. Finally, the Appeals Chamber notes the existence of evidence that Mr. Perisic had some control over promotions and resignations within the 40th PC. The Appeals Chamber also notes that Mr. Perisic was heavily involved in SVK operations through his management of VJ aid and possessed the power to approve or deny particular requests for assistance and secondments. This evidence suggests that Mr. Perisic had some influence over VJ members seconded to the SVK. Having assessed different types of evidence relevant to Mr. Perisic's effective control, the Appeals Chamber will now consider whether this evidence, assessed in its totality, proves that at relevant times Mr. Perisic possessed effective control over SVK members implicated in committing crimes during the shelling of Zagreb. The Appeals Chamber again notes the circumstantial nature of the relevant evidence. In these circumstances, a finding of effective control is possible only if that is the sole reasonable inference from this evidence. The Appeals Chamber concludes that while some evidence on the record is consistent with Mr. Perisic's possessing effective control over soldiers seconded through the 40th PC, other evidence on the record suggests that during the shelling of Zagreb, Mr. Perisic did not possess effective control over members of the perpetrators of charged crimes in Zagreb. In these circumstances, a finding that Mr. Perisic exercised effective control over those who committed crimes in Zagreb during the shelling of that town is not the sole reasonable inference from the totality of the circumstantial evidence in this case. Thus, Mr. Perisic's effective control has not been proved beyond reasonable doubt. Absent a finding of effective control over subordinates, superior responsibility cannot be established. Thus, the appeals chamber reverses the trial chamber's finding that Mr. Perisic was liable for failing to punish relevant VJ soldiers serving in the SBK for their actions during the shelling of Zagreb. Mr. Perisic's remaining submissions regarding superior responsibility are therefore rendered moot and need not be addressed. For the foregoing reasons, the appeals chamber finds that the trial chamber erred in convicting Mr. Perisic for failing to punish VJ soldiers seconded through the 40th PC for crimes that took place during the shelling of Zagreb on 2 and 3 May 1995. Accordingly, Mr. Perisic's 13th ground of appeal is granted. I shall now read out the full operative text of the appeals chamber disposition. Mr. Perisic, will you please stand? For the foregoing reasons, the appeals chamber, pursuant to Article 25 of the statute and Rules 117 and 118 of the rules, noting the respective written submissions of the parties and the arguments they presented at the hearing of 30 October 2012, sitting in open session, grants Judge Liu dissenting Momcilo Perisic's second and third grounds of appeal in part, reverses Judge Liu dissenting Momcilo Perisic's convictions for murder, inhumane acts, and persecutions as crimes against humanity, and for murder and attacks on civilians as violations of the laws or customs of war, and enters Judge Liu dissenting a verdict of acquittal under counts 1, 2, 3, 4, 9, 10, 11, and 12 of the indictment. Grants Momcilo Perisic's 13th ground of appeal, reverses Momcilo Perisic's convictions for murder and inhumane acts as crimes against humanity, and for murder and attacks on civilians as violations of the laws or customs of war, and enters a verdict of acquittal under counts 5, 6, 7, and 8 of the indictment. Dismisses Judge Liu dissenting as moot Momcilo Perisic's remaining grounds of appeal, and orders, in accordance with Rule 99A and 107 of the rules, the immediate release of Momcilo Perisic and directs the registrar to make the necessary arrangements. Judge Theodore Meron and Carmel Adjus append a joint separate opinion. Judge Luda Kun appends a partially dissenting opinion. Judge Arlette Ramarason appends a separate opinion. Mr. Perisic, you may be seated. Judgment registrar, would you please distribute copies? The hearing of the Appeals Chamber of the International Criminal Tribunal for the former Yugoslavia stands adjourned.
All rise. Veuillez vous lever.